All right. Hi. Thanks for joining me. Freedom is Scary, episode 54. And I wanted to talk a lot more about really what is the COVID fascism. And that's just the more I think about it, the more angry it makes me that not just that you have the government now telling us to wear something over our face that restricts breathing when it doesn't even, according to the statistics and the science, which I'll discuss, do anything. But the fact that we're doing it to children, and I think that is where the next sort of challenge that I'd like to make, and I want to discuss that also with some of my colleagues from surrounding states. We have here also Chris Wiest from Kentucky, who's been suing the Kentucky governor and successfully as well over some of the mandates. And also with me is Andy Fox from Knoxville, Tennessee. So I'll go ahead and bring them on. Hey, Chris, Andy, how you guys doing? Can you hear me all right?
Yep. Yes, doing well. Thank you.
And I'll also note that Chris is in Florida on vacation with his family. And he was so excited to discuss this topic that he had to sneak away for a few minutes just to talk to us.
Don't tell the governor of Kentucky I left the state.
Yeah, as I was just saying before we went on here, I was in, and I'm from Florida. I grew up in Florida. I was born in North Carolina, but I grew up there. Even went to undergrad there, and it was so weird coming back here a few weeks ago. And I'd been obviously spending time in West Virginia, but also I'd been, to your neck of the woods, but in Ohio, like once a month practically for my son's jiu-jitsu. And I've just been so brainwashed and used to having to deal with the mask stuff that it was crazy going to Florida. And as soon as I get there, yeah, there are some people wearing masks, but there's not this tension, this anxiety of like, oh God, can I go in this gas station? Can I go in this restaurant or store without a mask on? Am I going to cause drama for my family? There's like none of that going on. And there were no threatening signs on the doors of the businesses, and really just so much less anxiety over and then there's so many more people.
Right.
And there's business going on. It's like the restaurants are open, the movie theaters. It's like life is normal, and instead of like this just crazy like tension situation that we have up here. So,
right.
So anyways, I wish I was down there right now as well. But thanks for joining us. Basically, here's. I just sort of wanted to see what you guys what your thoughts were on this. I think we've all filed some lawsuits already against our respective governors over some of the COVID fascism, and this is sort of how Andy and I started talking, as we were both had been listening to Daniel Horowitz from the Conservative Review podcast and the Blaze. And he had this guy on named Dr. Stephen Terry, who is the nation's leading expert on industrial hygiene. And I had never heard of this before. But as it turns out, that is like the scientific discipline that has to do with masks, that has to do with, the science of particles floating around inside a building that could possibly be inhaled. And so therefore masks. And you don't hear this in the mainstream media. And so I had gotten in touch through Mr. Horowitz with Dr. Stephen Terry, and he is on board with being an expert witness in a new mask mandate challenge that I'd like to file in West Virginia, but I think would also be great to file in your states, and especially in Tennessee and Kentucky, because you guys have a better federal circuit, the Sixth Circuit, that I think would be more amenable to this sort of thing. But I think it should be done in multiple states to defeat this mask mandate, because, and hear what your thoughts are on it. But I think that there's something that everyone's been missing just legally that hasn't been tried yet. If there's if there's all these substantive due process rights under the 14th Amendment and these rights to privacy, the rights to get an abortion, all this sorts of stuff. I mean, there's all these rights that are nowhere in the Constitution that has come up in all this case law through the years. Then how is it that this doesn't invoke those same sorts of rights? The fact that we're having these cloth objects or other material objects put in front of our mouth to actually restrict our breathing. Like, isn't that a human right? Isn't that the right to, doesn't it invoke all sorts of rights? And I think that's sort of the theory that Horowitz was talking about, that I think that really needs to be tried and coupled with Dr. Terry serving as an expert witness. Here's my thing. We're doing this to our children. This is being mandated in schools. And even when our governors say, if we file lawsuits again and the governors back off of their mask mandates, the public schools we've seen from Texas, they're still going to keep their mandates. They're still going to make the kids wear masks. And we can go through the science, but that's what I was thinking. I know that we've, you and I had talked about this as well, Chris, but attacking the mandate from that route, like for the kids, on behalf of the children, because there is science out there showing that this is continuing to harm children. And I'll go through that. But anyways, that's my rant. Chris, you have things to do, obviously. Let's hear your response.
I have never thought that the appropriate venue to challenge this was in federal court on a substantive due process claim. In part, people tried that early on in the pandemic. There were some cases that came out of Michigan to the Sixth Circuit Court of Appeals. And what ended up happening, the Sixth Circuit basically said that if there's any possible rational basis, the government's going to win. And every single time the government comes on with an expert, in Kentucky, it's usually, in any of the big litigation, it's Dr. Steve Stack, the Commissioner of Public Health. And he puts on his testimony, and you cross-examine it as best you can. But he comes on and, he's got a study or two that says masks are safe. So, given that deference in that federal court context on substantive due process, I have never thought that was any means or method under which we're ever going to win. Now, there may be another angle, another hook on it. Maybe it's not substantive due process. Maybe it is the right to bodily autonomy and integrity under the abortion kinds of cases to make decisions for yourself concerning medical interventions. That now we're starting to get into fundamental rights where you're going to get a higher level of scrutiny in which, if you can, all of our lawsuits against the governor of Kentucky, whether it's the travel ban, whether it's the church ban, whether it's protest rights, the ones we've won on have been invoking fundamental rights under the federal Constitution. And, we've been up to the Sixth Circuit and back a couple times in some of these litigation matters. And, I think we've got to find a fundamental right if you're going to go federal on it. Most of the mask mandate cases that I've done have been in state court because I have found state court should provide greater autonomy. Now, we have just renewed a challenge to the governor's mask mandates and everything else because what happened in Kentucky was our legislature came in, clipped our governor's wings, and then they came in at the very final days of the session on March 30th. They passed a House Joint Resolution that ended the mask mandate, overrode a governor's veto, ended the mask mandates, ended business restrictions, ended capacity restrictions. And, of course, the governor says that that's unconstitutionally infringing on his executive authority, which is absurd. He parked a case in the Franklin Circuit Court with a judge that his father appointed who basically, just whatever the governor asks, that judge is going to grant. This judge has issued orders in joining legislation. Like, I've never seen anything like it in my entire life. But so that's going on. And then there's two parallel lawsuits, one that we brought in Northern Kentucky in the Boone Circuit Court. This is, wait a minute, this is all over. We want an injunction against the governor. And by the way, the paper that judge in Franklin County's writing on isn't worth the paper it's written on because, you can't join legislation. That's bedrock constitutional law 101. And then there's another group of plaintiffs that have brought a similar case to ours in the Scott Circuit Court, which is probably another favorable venue for these kinds of challenges. So we've got, we're sort of looking at state court as being the better alternative. But, I'd be interested in your guys' thoughts on is there a federal fundamental right that could be a hook on this? Because if there is, then I think then I'm interested in federal court. But I've not figured one out yet, and I'm uninterested in doing a due process because that Michigan case, it was a published case. I'll try and get the site before we're off this call. I mean, that's just bad case law. If you're looking to bring one of these challenges in federal court under substantive due process, no matter your evidence could be laid down absolute great, but the government's going to put another countervailing expert on, and that's going to be the end of the case because that dispute itself is going to create a rational basis for the government's restriction, in my opinion. I'd be interested to hear what you guys have to say.
Well, the one thing that has changed, and I tried every federal claim I could think of when I challenged our mask mandate in federal court, and they all were shot down. I even tried First Amendment and I think it's invokes the First Amendment, but they just weren't going to agree with me. But one thing that's changed is that just time has gone on, and I think the arguments have gotten stronger. For instance, with the First Amendment, I mean, it's time is proving how much of a political speech issue there is related to masks. Also, time is showing the numbers really weren't affected at all by the mask mandates. That's one thing that's different. And I agree, the state court obviously is the stronger claim, but you have the problem like I have in my state is that the state Supreme Court, they have their own mask mandates when you go to appear before them. And they're going to make you wear a mask if they even let you in the building. And they're just not going to do it, unfortunately.
So, and by the way, the site on that is League of Independent Fitness Facilities and Trainers, Inc. versus Whitmer. I mean, it was before two conservative judges and one that wasn't as conservative. But I mean, the conservative judges have been the ones we've been running to in the Sixth Circuit on this stuff. I think it's going to be tough in the Sixth Circuit.
What do you think about trying the old college try again in light of Gorsuch's concurring opinion in that case? What is it, the Bronx Diocese? Have you had an opportunity to read what he said about Jacobson? He said that actually that the standard articulated in Jacobson, and just to preface that, I think Jacobson is bad law in light of the evolution of civil liberties throughout the the 60s and so forth, and 70s and 80s and 90s. But Gorsuch basically said in his concurring opinion that this is really strict scrutiny. This is the 1905 way of saying strict scrutiny. Have you had a chance to see that?
So I have, and I should disclose, we did the church cases, the Cuomo case that Gorsuch and his colleagues cited was Maryville Baptist and Roberts versus Nice, which were parallel cases that we did with Liberty Counsel on Kentucky church closures. And, again, Jacobson, we were fighting the Jacobson battle back in April with the governor in May, and the Sixth Circuit basically said, look, Jacobson doesn't apply when you're dealing with fundamental rights. But again, I'm back to, what is the fundamental right on a mask mandate, right? We're not dealing with freedom of speech, religion. I don't know that we're dealing with the Fourth Amendment search issue, obviously. So, what's the fundamental constitutional right that's at stake? It can't be equal protection because we're dealing with, not a suspect class that would trigger strict scrutiny. So, the only angle I have thought of is possibly arguing bodily autonomy and integrity in akin to the abortion context. I think that's a stretch, but that's the only angle I've thought of. Otherwise, and again, in Cuomo, that was a fundamental rights case dealing with, free exercise and discriminatory restrictions, which then gets you into strict scrutiny if there's discriminatory restrictions, if it's neither neutral nor generally applicable under Smith. So that makes sense in that context for fundamental rights. But the question is, how do you get a mask mandate question into federal court in a way that's going to implicate a fundamental right? Because otherwise, it's rational basis. And rational basis, even for the most conservative jurist that hates these restrictions, and I think, a lot of them do. A lot of judges think that this is absurd, the conservative ones at the federal level. Again, I go back to League of Independent Fitness Facilities and Trainers versus Whitmer. None of those conservative judges, I'm sure, appreciated Governor Whitmer's restrictions. I'm sure they thought it was absurd. But again, it's rational basis. And so if there's even a plausible explanation or basis for it, the government's going to be upheld unless you can get this into a fundamental right context to trigger strict scrutiny, at which point you're out of Jacobson, because Jacobson, again, was a case that was ultimately, and I think this was part of Gorsuch's explanation, was ultimately, about substantive due process, which is the most deferential review to the government. You got to get it out of that if you're going to successfully challenge it in federal court. Now, state court, different animal, which is where we've gone with some of these business restrictions and mask mandates and stuff. We've said, wait a minute, under state law and under state constitution, it's unconstitutional. Of course, you can't bring those claims in federal court under Pennhurst. The government's going to have 11th Amendment immunity to claims under the state constitution or state statute. So, the way to you bring the state claims in state court. But I'm interested. I mean, what do you guys think about the angle of likening a mask mandate to an abortion restriction and bodily autonomy? Because that's about the only angle I've come up with.
Well, I've got another one. How about this? It's got to be tied to religion now. That's going to be the only way to do it. Is all right. Islam, obviously, you have burqas and burqas and whatever the other ones are called. So, I mean, that is a component of a religion that has to do with wearing stuff or not wearing stuff. For Judaism, sometimes you have the little hats from Judaism. Greek Orthodox Church, sometimes that has to do with clothing. Really, the maskism has become a religion. And why can't it be all right if it's their religion to force healthy people, including myself, hopefully, to wear a mask? Why can't it be my religion now to not wear a mask? And I'm sure that's been tried by somebody. But as time goes on, if you can have if you can have with the vaccines, if you can have a strong moral objection to taking a vaccine, and that works in federal court. Now, that's different, but at some point, where does a strong moral objection to wearing a mask or letting my kids wear masks or forcing them to wear masks, where does that cross the line into something religious where you invoke a fundamental right? That's kind of what I've been thinking.
So that's a great angle, actually, and one I didn't think of. If you're in the religion, which again, that's the Maryville case, that's Roberts versus Nice, that's Cuomo out of the U.S. Supreme Court. Now you're looking at the mask mandate, and if it was a flat mask mandate and it applied to everyone, with I think they could get away with an age restriction, saying age 2 or under, but that. Typically all these mask mandates have other exceptions to them, right? Where they can
but the problem is the governors are having corporations and private businesses enforce those mandates for them. And so while our mask mandate may say that there are medical exemptions, the stores aren't allowing for those exemptions. They're forcing it on everybody, and I know that's a different issue, but maybe it shouldn't be. Maybe at some point that's like government action.
Well,
I don't know.
I mean, that's an ADA issue. I mean, we've talked
Yeah.
about it. No, I think somebody somebody could argue that they're impacted, that they're harmed by this, that they have a sincerely held religious belief not to wear a mask. And then the question is, is it going to be a valid, sustained challenge? And what I would say is you got to look at the exceptions. I mean, that's how we litigated the Roberts case, the Maryville case. That's how Cuomo came up. You got to look at the exceptions. Are they allowing, similar secular activities to occur? And I think if you could make the argument that they are, and I'm guessing you may be able to in some contexts, maybe the religion is the angle to go about doing this. If the government can prove, though, that it's neutral and generally applicable, that it's not hostile to religion, that it doesn't single religion out, and that it treats religion no differently, the religious exemptions no differently than the other exemptions that they've got, then it's going to be upheld, and you're back to rational basis under the free exercise line of cases, which is the Smith, the Smith case, which is sort of the seminal religious case. Although I guess we should mention there's a Smith is sort of up for review. This whole freedom of religion thing is coming up. There's a case out of Philadelphia regarding adoption placement services, where there was a Catholic organization that declined to adopt or place children with homosexual couples, and they argued that they weren't going to do that under freedom of religion. That's in front of the U.S. Supreme Court right now, and in part, I don't know if you know, like Cuomo came out, and then 2 weeks later we had the Danville case that came out of Kentucky when the governor shut down all the religious schools that we sued, and a bunch of other people, the Attorney General sued. And they kind of punted on that, the U.S. Supreme Court did, in part because there's this decision that's coming up out of Philadelphia. I'll have to get the case name before we're off this call, but that's going to relook at freedom of religion and may change the entire dynamic. The Smith, neutral and generally applicable. So I think maybe the freedom of religion claim we may want to look at after SCOTUS decides this Philadelphia case, because the entire analysis and framework could be different. And, that's a case a lot of people that do First Amendment religious liberty are looking at. I know we are, the Kentucky Attorney General is, kind of everybody's watching that case. And as you're probably aware, U.S. Supreme Court cases are out for this session. They'll be out by the end of June. So we'll have an answer on that. And I know it was argued back in October. I'm going to get I'm going to go cheat and get on SCOTUS blog and go look at get the case name for you guys. But I do think we need to watch that case, and that could be a decent angle, the freedom of religion angle.
Or when you get off, you could just post it in a comment at some point. I wanted to see, Andy, I had a question for you. I'll just throw out there also, I mean, there's got to be something that applies. I mean, it just cannot be even federally constitutional what's going on. Maybe Fourth Amendment. I mean, is it an unreasonable seizure covering your face?
Yeah, well, I shot the shotgun and incorporated a lot of these theories when I filed a state case, a DEC action in state court against Knox County because of their mask mandate. And I brought in the search and seizure issue, that it was, unreasonable seizure of the person in light of, we haven't done anything, right? I'm just existing, and the state has seized my body and forced me to wear this. So yeah, I'm trying all the different angles. Now, I pursued this under, Tennessee constitutional law, and now Tennessee, there's a couple cases, a famous one, at least in Tennessee jurisprudence, is Planned Parenthood versus Sunquist, which it was that was a case that was used to expand abortion rights back in the 90s. And I really would like to use that case and flip it and expand it for our bodily integrity argument. And that's what I'm pursuing under that. But Tennessee Supreme Court justices have always had almost contempt for what they call the lower levels of protection afforded under the United States Constitution. So they say, hey, we have really robust rights here in Tennessee offered through the state constitution, and that's why I've been filing cases in state court. But I am interested in filing Section 1983 against the Knox County school system, and I'm going to make a bodily integrity claim in that case. That was always, though, what I thought out of all the theories that we had was probably going to be the strongest one, just because that area of law was so developed with regard to the abortion jurisprudence and the jurisprudence for resisting medical treatment.
Have you had any success in any of the cases you filed so far in Tennessee?
I can't get to the merits. I mean, it's like I have to go through all these hurdles of motions to dismiss. And actually, the case I filed against Governor Lee in state court in Nashville, the way I describe it, if you guys remember the old Westerns, where they show this scene of somebody outside a saloon, and next thing you know, you see this guy thrown out by 50 people and the doors are swinging. That's what they did to me in Nashville. They just threw me out very shortly after I filed the case. And, I filed an appeal, and it's actually scheduled to be heard, the oral argument, here in the next month or so. And of course, they even now they're throwing a mootness argument at me because at the last minute, although the case was supposedly moot just maybe a week after I got thrown out of court in Davidson County, they waited until they filed their appellee brief to raise the issue of mootness, try to throw it at me at the last minute, give me 2 weeks to respond to my reply brief. I asked the court for some more time. They granted it. So that's an issue too. I'm representing a skating rink that was locked down in that particular case. And the restrictions on gatherings of large people were removed shortly after I filed. I think we have a pretty good public interest exception, though. This doesn't come up very often, right? Just shutting businesses down at based upon a hypothesis that spread may occur and so forth. So I think we have a pretty good public interest exception. But even with this particular case and against Knox County, that's mask oriented, as soon as I filed it, even though I filed it in state court, made clear that I was pursuing under a state theory because I mentioned the United States Constitution. I got dragged back up I got removed to federal court, and I had to putter around for about a month and a half, and then I got remanded back to state court. Then it turns out that the chancellor I was in front of was retired or was stepping down from the bench, so we had to wait till the new chancellor got on board. It's just been one thing after another. I can't get to the merits, but once I get to the merits of some of these things, I'd really look forward to using the expert that you've gotten on board, because I think he can bring the real expertise. I can't wait to argue to the court that doctors aren't even experts in this field. They're not the ones. I liken it, if you guys can think of a better illustration, I'd love to hear it, but I like it in a sense to a race car driver or a dirt bike racer. They know a lot about the engine. They use it. And they know how it works, but the real experts are the guys that build it. So I'm trying to find a better illustration than that. But that's kind of how I want to portray it to people is doctors know a lot about PPE. They use it. They understand how it works, but they're not the experts.
I got a good example for you. I got a real good example for you. Even my own father, maybe he's watching this, orthopedic surgeon, retired, replaced knees and hips his entire career in Florida. And if anytime especially when I was really lifting weights a lot, competing in amateur strongman, we would have arguments. He would tell me, that it's not healthy to do, like squatting certain weight, is not healthy, or you go below parallel with the knees, it's not healthy. And it's just like, well, I'm an orthopedic surgeon. I've seen, like millions of x-rays and change these things and so on. But, I maintained, and I believe it's the case, that just because you're a doctor, an orthopedic surgeon, that doesn't necessarily make you an expert in all things related to the legs and the knees. Doesn't make you an expert in lifting form. That doesn't make you an expert in all things related to it. Whether your back should be parallel, whether your eyes should be looking down or looking up. There's other disciplines that are more focused on these things. And you see, in what you do, maybe you see a different sample of people, whether older people or maybe non-athletes or athletes, depending on what you do. But yeah, maybe that wasn't as good an example as yours, but I think that's a great point. In fact, the affidavits they gave me in my federal mandate challenge was just a kind of a catch-all from the DHHR, from the head of the DHHR, that says this is the worst pandemic ever, and this is such a serious situation. I mean, it wasn't scientific at all. Cited no scientific studies, and this is what was upholding it in these challenges, and they used it in the state court challenge as well. And I actually cited the Danish mask study, which was like the first one out, and they responded to it, but they didn't introduce any competing science. And I just think at this point, we have more and more and more science that has to strengthen the claim. The other idea that you gave me is this, like, if the state law claims are the best, right? So, I mean, separation of powers, because these governors have been acting like tyrants, exercising the powers of the legislature. You could make a federal claim in a state law case, let them remove it to federal court. We may have lost Chris there. Let me.
I think I'm back on. Is that any better?
Okay.
Yep.
Yeah, you freeze framed on me. But Chris, what I was saying is, all right, the state law claims, like you were saying, are the best because you have the pure separation of powers arguments. And unless you just don't care, if you're a judge, unless you just don't care, like, it's obvious that the governor is exercising the powers of the legislature. It just is, especially if he's having people arrested and shut down for a year now. So you make a state law claim, and then you also include the federal claims in it. And you provoke them into removing it to federal court. And then, correct me if I'm wrong, there's a case to be made that they have waived the 11th Amendment immunity.
To be made. That is the case. If they remove, that is a waiver of 11th Amendment immunity.
Yeah. So then, either they let you also litigate. I guess the smarter thing for them would be to just not remove it. But and hopefully they're not going to watch this. But yeah, I mean, hell, if they remove it to federal court, then we get to also make those state law claims. And the federal judge is going to have to explain in writing why we're not right. And that's the one thing I haven't not been able to get is any written explanation on the state separation of powers issues. Why does a governor get to be the legislature also for the past year? I haven't seen that explained ever.
Well, that was the main theory that I used in the case against Governor Lee, was a separation of powers issue. And, what I found, I don't know about you guys, but what I found in Tennessee is that the judiciary for so long, for decades and decades, has basically been an apologist for the extension of near legislative power to the executive branch, that now it makes it difficult to challenge because of the tests that they developed. It makes it really difficult to show that what the governor's doing is effectively legislating. The test really doesn't even, the tests they have don't even contemplate this kind of thing. They contemplate some like the Tennessee Wildlife Agency, making various classifications of animals and things like that. And, somebody raised, some livid hunter raises it and says, hey, you can't, you're making legislation. It should be the legislature that classifies animals. And so they, the Tennessee courts then developed this test that allows the bureaucracy to take action like that. That's not what we're dealing with at all here. We're dealing with an expansive use of emergency powers, and really the executive has he's just flat out making law. He's repealing law effectively. It's crazy. But I mean, maybe, with this appellate hearing, I can get some traction. It'll be the first time I've gotten anything close to bringing merits before a bench, though.
I think we may have lost Chris. I'll try to bring it on one more time and see if he's on there. Chris, are you still with us?
Yep, I'm with you. Sorry.
Yeah. Andy, can you see Chris? It just looks like a black screen to me.
I can hear him. Yeah, I can hear him, but I can't see him. But that's good enough. We'll keep you on, man.
All right. Yeah, we're in a different place in Kentucky.
Does that sound the same way to you?
Yeah, it sounds like that Star Wars robot.
Yeah.
Let me try to reconnect you.
Yeah, maybe I'll kick you off and maybe reconnect here. Yeah, it's the somebody's cutting off our connection here. One of the governors has found out, it used to be like in the 1774, 1775, like it's like you went into the bars to talk, freedom, liberty. That's where all the freedom talk took place. and so they had to be shut down. I mean, the governors, the colonial governors, had to shut the bars down. Like Lord
Oh, wow.
Dunmore, we had in Virginia, here in Virginia. They had to shut those bars down because that's where this rebellious discussion was taking place. And here in 2021, here in 2021, that's taking place on the internet, and of course, big tech is helping these governors and bureaucrats and Biden and shutting down all dissent that takes place on the internet. But we were afraid that that's what had happened here. But
no, you guys need to read Justice Thomas's dissent from or concurrence and denial regarding big tech today that was at a SCOTUS, by the way.
Yeah, I saved it. I haven't read it yet.
It's worth reading. By the way, the free exercise case that's in front of SCOTUS is Fulton versus City of Philadelphia, Pennsylvania. And if that's the angle, I would keep an eye on that. That decision will be out by the end of June. Obviously, a bunch of us are that do any kind of religious liberty work. I mean, that's and it's going to revisit possibly the Smith case, Employment Division versus Smith, which is the religious liberty sort of test case on neutrally and generally applicable. So I'd keep an eye out on Fulton. I think so. Our state case is a little different than I think your guys, because we're going in with a legislature that just literally clipped all the governor's powers, and we're arguing that the orders are now illegal under the legislative enactments, and the governor's arguing the legislative enactments are unconstitutional. And I think that's just a different sort of posture when you go in with recent legislative enactments at your back, even with a liberal judiciary. And I think, I don't know that our battle is necessarily as uphill in light of that. The other side of it is we have 4 of our 7 Supreme Court justices up next year, and I think a lot of them are going to have re-election problems, and they know it. So I'm not sure where this is all going to shake out in Kentucky.
Yeah, I mean, maybe Andy can tell us about Tennessee, but I'm not sure how much, Chris, you followed the legislative session here in West Virginia, but it's been an absolute disaster. I had sued the governor to force him to call a special session of the legislature. Of course, if that were successful, who knows what they would have done. But now we know for sure, because they've had their regular session, and not only did they not stop the state of emergency, still a state of emergency 13 months later, they can stop it at any time with a simple majority vote. They haven't done so. They were supposed to pass a bill kind of also clipping our governor's wings by putting a 60-day time limit is what our House came up with, where he's got to bring in the legislature or get their consent to exceed 60 days of a state of emergency rule. And that passed the House, and the Senate basically kicked it out and destroyed it. So we have no legislation from this legislative session that limits or restricts the governor's supposed emergency powers at all. It's been a complete failure. So how can I even make the argument? Well, I can, but it's a much weaker argument that the governor's usurping the legislature when the legislature is explicitly giving him permission to do so now, which they shouldn't be able to do.
Right.
Andy, what's going on in Tennessee? I mean, did your legislature, or were they a complete failure so far as well?
I'd give them a B, maybe a C. They took some action. It wasn't as strong as I would like. They've. I don't know where well, first of all, they're not done yet, so I don't know where it's going to end up. But they did take a stab at the emergency powers statute that gives the governor all the power that he's been wielding. And by the way, there's an interesting phrase in that it says he's only supposed to do it for 60 days unless renewed. Now, I think it's arguable that the longest contemplated by the statute that a governor could declare an emergency to be in place is 120 days. But that's that's an ambiguous part of the statute. I might have to dig into legislative history on that. It arguably he cannot just renew ad infinitum. He has a one renewal and that's it, one and done. But of course he's not abided by that. They did also modify, or in the process of modifying the powers of these unelected boards of health to implement mandates like mask mandates or take action in emergency situations. So they've done a few things, but Tennessee has a problem with entrenched, old guard, moderate Republicans who control the process, and so there, you have kind of like a freedom caucus in Tennessee.
Don't we all?
Yeah, they don't have they don't have control.
We have the same problem in Kentucky, where leadership controls the agenda, leadership controls what passes, and we've got, I call them the liberty legislators, trying to like buck that, but there's just not enough of them. We had a bill in Kentucky that would have allowed for civil disobedience for businesses and basically said that the governor not only couldn't take business licenses, but had to give anything back that he already took for his COVID mandates. I mean, it was a fantastic bill, and it just could not get traction. The Kentucky House leadership killed it. So, I think we were all, sort of suffering the our zoos are filled with rhinos, and, it makes it kind of challenging.
Yeah, but at least your legislature did something. I mean, ours is, the Senate all but one, and who was a Democrat, voted to not restrict the emergency powers. All but one, including the primary one, Senator Charles Trump, had expressed the opinion prior to the legislative session that he thought this was an unconstitutional expansion of the emergency power statute, and he was going to do something about it. And then when the time comes, a week before it's over, boom, he kills it, and there's not time to do anything else.
Yeah. Well, and I don't know, but it sounds like you guys are like where we are, where everything they've done now, we've got to go litigate for the next year because ours are out and part-time. I think West Virginia's is Tennessee full-time, or are you guys part-time also?
Part-time. We go basically from middle of January through or February, beginning of February through about May. If it goes past May, it's really unusual. It has a couple times in recent history, but it's part-time. Yeah, and I guess, I'm grading them on a curve. I think if we talk to Daniel, he'd still give Tennessee's legislature an F. But I'm trying to, I'm grading them relative to some of the other fascists around the country. We're not the worst. We're not the best, but we're not the worst. Yeah.
Yeah. Well, when it comes down to it, I definitely get more angry about the mask stuff when I do listen to Daniel Horowitz. He has a way of putting it, but when I think about it, it's absolutely true. I mean, this has all happened so quickly. Who would have thought that in just 13 months or 14 months that our way of life would be completely different, and that we'd be forced to literally cover half of our face with some sort of material. I mean, it's just, it really, and irregardless of any science behind it, it just really is, it's unbelievable. There's no precedent for this at all. And I feel like if it's got to be stopped, and if we don't stop it, I mean, there's no stopping anything. Talk about the slippery slope. If they can do this and get away with it, then, I mean, we're done. I mean, there's no stop. Government can do anything to you, anything it wants, anytime it wants, if they can get away with what they've done already.
Well, the progressives found they found that using a Hobbit analogy, the dragon, and there was one spot in the dragon's armor where it was vulnerable, or an Achilles heel. What they found was this health emergency thing, because and they really worked off that, and they capitalized off the weakness afforded to governments purportedly to take to take liberties with our liberties when confronted with medical issues, pandemics. It almost seems like they planned. I mean, I'm not saying they planned it, but it's just so interesting that maybe 20, 30 years ago, for instance, the statute that allowed the governor to take the actions he took were in place. So for a long, long time in Tennessee's legal history, a governor couldn't have done what this governor did. And then 10 years or 5 years after they created the emergency statutes, they added the health and sickness as part of the pandemic. So it wasn't even part of the original thing, part of the original Emergency Powers Act, this power afforded to act with regard to sicknesses and pandemics. But that's what they did. They capitalized off this weakness.
I put up this comment here by Bill Bosso. I think that brings up a good point, and why I think it would be helpful to use Dr. Stephen Petty in challenging these things, because the whole point of this is that we know now that really if you're inside a structure, and this is what he has to say basically, that the COVID particles are so small. They're like half the size of asbestos particles. And you can't just wear a medical mask or any sort of mask to stop an asbestos particle. I mean, it goes right through it. It's so small. You could wear 100 masks. And also, if it's so small, it floats out there. If you're in a room and you're breathing out a COVID-19 particle, I mean, it could take hours or all day to drop to the floor. So if you're walking around, it doesn't matter if you stay 6 feet away from people at all times, because you're gonna catch it. So the only thing that you can do is be outside or improve the ventilation to bring air up and out and bring fresh air in. Those are the only two things you can do. There's no staying 6 feet away from somebody. Doesn't have anything to do with it, because you can enter the room after when there's no one else in it, and the particles can still be floating around. They're so small, and you can wear all the masks you want, and it's going to go right through the mask. And that's exactly why these charts show that there was no effect. Social distancing, the mask mandates had no effect. The virus is going to run its course like viruses do, because they're floating around.
I read Bill's comment to be a little different, that actually that the masks were harmful, were raising CO2 levels for people to breathe in, and as a consequence of that, we're possibly endangering people. And I think if you could prove that these mandates were actually causing people physical harm, that the wearing of masks were causing physical harm, that's a very interesting case to make, under the bodily autonomy line of cases, under even Jacobson, because Jacobson, pointed out that there was no evidence in Jacobson that this was dangerous. And so I think, there's always been a line of cases that you have the right for the government not to physically harm you, right? I mean, that's fundamental due process. They can't fundamentally harm you. I mean, maybe that's the argument.
Well, in fact, that's the second part of my proposed argument here. I don't know what legal theory it best fits under, but it's the 1-2 punch, and it's absolutely correct science, and it can be packaged in a way that all you have to do is read it, and now people are equipped to expose all the BS. Like they understand. I think there's a good educational component to challenging this thing again, even if it's ultimately going to lose, because the people can be enlightened to what the truth is. Because so number one, Dr. Petty's truth about the actual size of the COVID particles and being spread aerosol, it's just a joke. Social distancing and masks are a joke, because you can't even use a real respirator that's sealed to stop particles that small. So it's literally just a joke. And the second part of the 1-2 punch is there is science out there right now showing that it's at least with regards to children, that masks are doing harm. So I think that can be proved right now, and I can actually put some of this up. And Daniel Horowitz had sent this to me today, because I know I've heard it talked about, and I'm asking, where is this science, so I can actually insert it into a legal document. And here's one of the studies. So right here, this is a German study, I believe. First results of a Germany-wide registry on mouth and nose covering of children with masks. So this is good science right now that could be used in a lawsuit. But this is really astounding, and you won't hear about it in our media. But combined with the fact that masks really aren't doing anything positive, they're doing negative. So it's not very long, and I'll put this up in the description of YouTube so that people can find it. But look at all the harm that it found with children being mandated to wear masks: headaches, concentration difficulties, discomfort, impairment in learning, drowsiness, tiredness. Now, impairment in learning, so applied to kids in school, they're there to learn, and yet they're being impaired to learn. And that also reminds me of people who are hard of hearing. I got three brothers. One of them is like 40% deaf. He reads lips. You'd never know it if you met him pre-2020. He reads your lips. You'll never know he reads your lips. And he's able to communicate perfectly. But now with everyone wearing masks, he can't hear. I mean, he can't hear what you're saying. It makes it very difficult to communicate. But he's an adult. There are kids like that. Impairment in learning, drowsiness, tiredness, tightness under the mask, shortness of breath, dizziness, syncope, unwillingness to move, unwillingness to play, itching in the nose, nausea, feeling of weakness, abdominal pain, accelerated respiration, disease feeling, tightness in the chest, loss of appetite, flickering eyes. I can't pronounce that. Noise in the ears, short-term impairment of consciousness, fainting spells, vomiting, more irritated than usual. The child is less cheerful, no longer wants to go to school. The child is more restless, and on and on and on. So kids are getting more anxious. They're getting more depressed. They're actually having physical impairments related to wearing masks. And this is a scientific study. So based on our data, in the conclusion, it can be said that the effects of compulsory masks on quality of life, and presumably also on health of individual children, should not be ignored by politics and society. Parents, teachers, doctors report stigmatization, exclusion, and aggressive behavior towards children who do not wear a mask for psychological or medical reasons. And inappropriate use of masks, which tends to happen with children, may increase the risk of pathogen spread, transmission through the increased tendency to put their fingers in their face. It may be worse than not wearing a mask at all in some cases. 66% of the interviewees showed a clear and broadly diversified burden of complaints, both in physical, with rashes, headaches, etc., as well as in mental, fears, irritability, etc., and intellectual concentration disorders areas in the children of the interviewees. So, and then they also bring up significantly experience health impairments in the long term. And so there's all sorts of stuff that we don't know, but there's even provable things that we do know now that shows that this is not healthy for children. And there's actually also science from the WHO, and Daniel sent this to me. I'll share this real quick. If you look at the WHO's own website, where is it? This is useful as well. Where'd it go?
While you're looking for that, I just want to point out too that I think it was in 2015 that there was a study out of East Asia. It may have been Vietnam, where they studied a number of nurses that wore masks and talked about or discussed how there were those same outcomes that you're describing. In other words, this study that you've just been talking about is consistent with other studies that show these negative impacts, these qualitative impacts that wearing masks constantly can have on people, and in fact can actually lead to greater incidence of sickness. But it's so hard to pierce this veil of fear that the layperson has right now. I don't know if you've gone out in forums and tried to, shed light on people's irrational fears, but I have some relatives that I was saying, hey, look, just read what OSHA says about masks. OSHA itself says they don't protect from the transmission of infectious agents due to insufficient filtration and improper fit. And they told me, because I was challenging their worldview, effectively their religion, they're like, oh, well, OSHA, they're just saying that to cover themselves so they don't get sued. I mean, you can't convince them of anything, of fact. They won't listen to it.
Or are you when did you get your virology degree?
That's
what they like to ask you. Or you don't, no, I believe in science. I mean, it's absolutely insane. That's why I'm saying this has gotten to the point of religion.
So can I, it's interesting to me. I mean, these studies have been out. We've used some of those studies. What I find to be the most effective way to challenge this stuff, I mean, yes, bring in your own expert, but if you get into a battle of the experts with the government, generally the government expert's going to win, depending on who the judge is. And what I find to be the most effective thing to do is to cross-examine the government's expert. And so, in Kentucky, our Commissioner of Public Health is Dr. Steve Stack. He loves me because I've had probably 3 or 4 go-rounds and a deposition and 2 or 3 court hearings with him, where you just, and you're right, you got to challenge the assumptions. You got to do the drill. That's what that's what trial lawyers do. You challenge the assumptions, you challenge what are you basing that on? You do the deep dive with them. And ultimately, in one case, we got we got him to admit that the mandates weren't based on science, but were based on the governor's value judgments about what was important and what wasn't. I mean, when I was all done drilling down with him after like an hour and a half long battle with him through cross-examination and deposition, I got him to finally admit it, right? I mean, he admitted what we all knew, challenging this stuff, which is that it's government value judgments about what's important and what's not that's been driving all of these mandates. And so, but what I would say to you guys is, get the deposition of the public health experts and make them own it. And, that's where we earn our money is that kind of cross-examination. I did that in the federal case over protests. The governor was allowing Black Lives Matter protests on the Capitol steps while banning protests that were critical of him on the lockdowns. Classic viewpoint discrimination. The Sixth Circuit just absolutely shredded him 3 weeks ago in a published decision for it. But Dr. Stack's deposition didn't hurt at all, that effort, when we got Dr. Stack to admit that all of this was basically value judgments of the governor. And you guys got to do that. I mean, I think to have an effective challenge on any mandate is to boil this down and make them own it for what it is.
Yeah, got a great comment here from a doctor. This whole pandemic has run its course. There's not a single validated, credible study to show that masks do anything to decrease transmission or prevent spreading of the COVID-19 virus. And, the scary thing is that I know I've heard this from a lot of doctors who are scared to say anything because these medical boards, which are just like the health Nazis, are going to try to come after their license. And next they'll be doing that to lawyers as well. Like you dare challenge the government on their emergency powers trying to save people. Well, you've now become a danger to, obviously your mental health is unstable and you've become a danger to the public. So I've heard of them coming after doctors. I think it was in Washington State, maybe. So, and for that reason, I even asked my dad anything like that's recorded. Like, he doesn't. I don't know if he maybe wears a mask where he absolutely has to, but he spent his whole career wearing these surgical masks, and he's like, he's like, we never got any training on those. I always thought that it was just so we didn't drool on the patients, like open wounds while we're doing surgery. We were never told it was, to prevent any sort of particles getting through. But anyways, Dr. Tom, thanks for the comment there. The other thing I had here, and I had asked Dr. Petty if he mind if I shared some of his materials. He sent me some of his what he usually presents, and also Chris, if you've got to go, I'm sure you've got better things to be doing. Just let me know.
Yeah, well, I'll pop off in just a couple minutes. So
yeah, so you feel free to just go for it when the time comes. But this is basically Dr. Petty's. Where is it? All right, this is his like presentation that he does. So that's his name, Stephen Petty. He's an industrial hygienist. He's like the leading one in the country, from what I understand, and he's testified like hundreds of times in court, a lot of times in regards to asbestos stuff. And it's really the same sort of thing, like is asbestos in building. Oh, hey doggy, I got a visitor. And but this is, where is it? So he goes through all the basically busts all the myths of everything that we've been fed, and it's exactly the opposite. For instance, like just listening to the radio this morning, you hear the breath, the mint. What is it? The mouthwash company. She's like, well, I got my mask on. You got your mask on, so you're safe, but what about your bad breath? And I'm thinking, that's what these idiots think. They really are convinced that they're safe. They put on their mask and they're completely safe. And it's absolutely not the case, because personal protective equipment, PPE, is like the least desirable thing. And masks are not even PPE. And he explains that really would require a respirator with a fit, and you'd have to follow all those OSHA rules. So we act like you just wear a mask and you're protecting people, you're protecting yourself, but he completely debunks that. And so he goes through that. So PPE is not a good way to protect people. Masks are not PPE. And the evidence shows that the COVID-19 particles are mostly small aerosols, not droplets. So you would need respirators, not masks, to protect your lungs. And a 6-foot rule would be meaningless, as I brought up earlier. And smaller particles are likely a greater cause of disease, since they get past the PPE and can reach deep into your lungs. So it's like an upside down triangle of, well, what can you do to protect people? Well, the worst thing you can do is PPE. And again, those aren't even masks. And then like the second best, that's the least effective. The second least effective is administrative controls. It was what the government likes to do, limit times and exposure areas. So you can or cannot go in a certain place. And then the better things are engineering control. So, diluting or destroying or containing the COVID-19 particles. And there are ways, I heard this when he was on Horowitz's podcast, there are things that you can buy that will destroy COVID-19 particles, like in a building. So we're spending billions of dollars on sending into foreign countries, like all sorts of stuff in these stimulus packages unrelated to COVID-19. Really, that's a lot of money. We could actually be buying devices that we could put places and in buildings that would actually kill viruses, but we haven't tried any of that. And then
go ahead. I'm sorry.
Yeah.
I didn't mean to interrupt.
No. I'm just saying we haven't spent any money on things that there's science can prove it will kill viruses. If it's not cheap, but there are devices that can kill viruses floating around, or you can improve ventilation.
Right. I've dined in a place. There's a local political action committee that I'm a part of, and we had a lunch several months ago. And there's a company in Knoxville that manufactures those. They're called Sentries. I can't remember the name of the company. I met the guy that owns the company, but yes, there's a product out there, and it sends out fog, a mist that destroys the virus, all pathogens in the area that the mist covers. So I was just corroborating what you're saying, that yes, we have technology already available to combat it in that way.
I mean, if money is no object, which it hasn't been, I mean, our government has spent our money on anything and everything. Why was that not even, I mean, we know why. That's a rhetorical question, but there are things that we actually could have done that we didn't do.
So, one of the great proof points, and I think we're going to probably use it in a case, on our latest case on the mask mandate. If you look at case counts in Florida and Texas where these mandates have been lifted, on a per population basis, they're not substantively different than the lockdown states. And I think that the proof is literally in those outcomes that these mandates, I mean, if they're so great, you would see this huge disparity, and you don't see it in case counts and you don't see it in death counts on a per population basis. And I think that in and of itself debunks the theory that these interventions are in any way, shape, or form effective.
Yeah, there was a good article from the Federalist. I actually have it right here. I can pull it up. That it's from like late 2020 maybe, but it shows these charts and it's just absolutely blows them out of the water. So again, this is the Federalist, 12 graphs showing mask mandates do absolutely nothing. And this West Virginia's matches this as well. But
yeah,
let me
Rational Ground has prepared some of those graphs as well, comparing California and Florida, I believe, and the curve was almost identical.
Yeah, look, Austria and Germany requires masks. France, Spain requires masks. I mean, the virus is going to virus, and the UK. I mean, they're all doing the same shape. And look, they require masks, and then look at the climb. When the virus is going to climb, it's going to climb, even with the mask mandate, and everyone wearing masks. Look at that. Every single country in Europe. And I mean, the data is there. And then California requires masks. Boom. It skyrockets. Hawaii, even outdoor masks. Boom. It skyrockets. And then look, Texas versus Georgia. Texas requires masks. Georgia, no masks. It just does the same thing. And West Virginia fits that as well. And then New York, I mean, that's like virus is going to do it, but then government's really going to help it. I think is the only way to explain that. And then look at Sweden, I mean, they all follow this. And again, this is from like back in August, but all these charts are the same, and West Virginia is no exception. Our mask mandate, I mean, our numbers skyrocketed after our mask mandate. I think we may have lost Chris. Hopefully that was on purpose, and he's ready to go and continue his vacation instead of talking work here. But I appreciate him coming on. Yeah, absolutely. But yeah, it's crazy that if you question this to anybody, they point out that you're not a virologist, that you're not a doctor, and I mean the science is out there. I mean you don't have to be a virologist or a doctor or even industrial hygienist to look at these numbers which they're not disputing, that shows that the masks did absolutely nothing. And even in West Virginia, when the numbers started to skyrocket, everyone was wearing masks. In my own county here, we didn't even have it for a long time. But when it first came in, this is a rural area. Where did it come in? Inside the nursing homes, where everybody was wearing masks in the nursing home. I mean, the staff coming in, where they were wearing masks. They were making all the patients at these facilities wear masks, and yet it was spreading quickly, very quickly through these nursing homes. I mean, it was obvious to anybody who paid attention, who cared about whether or not masks help, that masks weren't doing anything at all. And when you look at the Dr. Petty's explanation, that's exactly why. Because if these are tiny aerosol spread droplets that linger in the air for like hours, you can't just wear a mask that doesn't stop the particles, and also walk around where other people who've been infected or have been breathing. I mean, it's going to do absolutely nothing. Just like those numbers show, it's just going to do it. It's just going to do it. So that's what I'm thinking. Anyways, the 1-2 punch there. I don't know what the right legal gymnastics are, but as far as the facts go, Stephen Petty's science on COVID-19 particles and the uselessness of masks, combined with some of the studies, just even that German study showing that there is real tangible physical and emotional harm to children that mandated mask usage results in. And I think we can see that, around us. And I think I told this story already, but last time I was in Ohio, coming out of a restaurant, I watched this other family walk out. And so they had their masks off eating. They walk out the door. They rip their masks off and they start to breathe again and laugh and joke with each other as they're walking down the sidewalk. But nobody takes the mask off. This little tiny girl that was kind of straggling along behind her family. And she had this huge mask on. It's like covering almost all her face. She's just a little toddler, tiny little girl. And she's trying to see where she's going. And nobody notices that she still has her mask on. And as far as I could see them walking away, she had this mask on her face. I'm just thinking, you know what? This is just child abuse. It really is.
Yeah.
And no one else is really thinking anything of it. But we're putting on these teeny tiny little kids. I mean, there has got to be all sorts of issues. I mean, so many kids already have depression problems and learning problems. And this is just aggravating it. And I mean, just like everything that we've done with these mandates. I mean, if what Dr. Petty says is true, and it absolutely is, then the lockdowns made things worse. Because if the only thing that helps is being outside and having fresh air brought in through ventilation, well, you're ordering people cooped up inside, and stop going outdoors, stop doing your regular activities, stop engaging in your business, and just stay cooped up inside, which you can't, obviously. Somebody's got to go to the grocery store and be around other human beings and get food, or someone with food's got to bring it in. I mean, you can be completely quarantined. So then when you introduce the COVID-19 particles into your home or whatever structure you're cooped up in, it's just going to float around in there. And no wonder it just made it worse. The worse the lockdowns were, the higher the spread was.
Right. Well, that reminds me of, I don't know if you also follow Steve Deace. I'm also, I follow his show avidly as Daniel's.
Yeah,
And,
I heard him on Daniel's show the other day.
Yeah. Well, Steve, he was one of the leaders with Daniel and Jordan Schachtel in putting together the data to combat the misinformation that was coming out of government sources early on. And by the way, I wanted to note what I tell people about COVID and understanding it when they say, oh, well, you're not a virologist, you're not this. I say, look, you don't need to have that kind of credentials. All you need is basic high school level math to appreciate the statistics to explain how this disease affects our society. But Steve pointed, in his research, he found that SARS-1 back in 2001, just basically went away on its own, except there was one place in Canada, it was a hospital, and they kept having problems with it. And it was because it was, it was indoors and it had a lot of fomites, and it was this, it was conditioned air. That's what led to the propagation of the virus. And we did everything backwards. We did everything opposite. We should have said, go outside, don't lock down. And our previous experience with, a pandemic like respiratory disease showed that.
Yeah. In fact, if neither one of us are experts on this, but Dr. Petty is. I'll bring this thing back up and show exactly where I'm getting this from. And I've been sort of paraphrasing his work here, but here it is directly with his presentation. So why are aerosols, these small particles, so important? So very small particles like this, as I said, can stay suspended for hours and to days. So since these little COVID-19 particles stay suspended in the air for so long, they can actually accumulate in concentration in indoor air rather than dropping out if you assume they were droplets. So this, if true, which it is, renders the 6-foot rule useless. It also renders masks essentially useless since they don't filter out aerosols. They could stop spit coming out of your mouth in huge droplets, but they're not going to stop with just the aerosols you're breathing out. And even if they could, since they're not fitted, they can't be fit around your face, gaps around the edges. So his example is this. Imagine a wall with a door and window openings, but with no doors or windows present in the openings. The wall is made of a chain link fence to represent a mask. The windows and doors represent the gaps around the edges of the masks. And so imagine the virus as a gnat. The gnat can readily get through the chain link fence, which is the mask, but can even more easily get through the openings at the side of the mask, the wide open areas analogous to open windows and doors. And that's it. It's pretty simple science that people like Dr. Petty have known for a long time dealing with things like asbestos. But it's completely ignored because that's what government wants is with COVID. And look at this. Small particles such as the COVID-19 particle take a long time to fall 5 feet in still air. All right, so look, time to fall 5 feet. And what is this? And what's the unit here?
60 days, 58 days. Is that what that says?
Yeah. So if you breathe out COVID-19 inside a non-ventilated indoor structure, I mean, you're looking at days and days and days before it even hits the ground. That's how small it is. So, and it could be longer depending on if there's any moving air. So, I mean, that's just insane. And what people are told that you should wear this mask and stay 6 feet apart and you're doing your part and your grandma's not going to, catch COVID-19. Well, if all this is true, then how many people thought that they were being, safe and responsible and were actually bringing it home to their elderly grandmother who then died afterwards? I mean, and so are they ever going to admit this once they've already, made these mistakes?
It seems like they're just doubling down. Is their approach now? They're not going to back off. It's funny you mentioned, bringing it home to grandma. The Knox County mask mandate, one of the ways that I was attacking it, I was saying, well, even if it is a compelling interest, to save us from COVID, and I argued that it wasn't. I said in light of past pandemics such as smallpox and dysentery and other things that truly were existentially threatening. I said it's not a compelling interest, but even if it was, this is not the least restrictive way to handle it. And one of the reasons is because it's arbitrary the way these mask mandates are imposed. Because you've probably done more strict scrutiny work than I have, but one of the thresholds is if it's the least restrictive way, it can't be arbitrary. In other words, a government regulation cannot be both arbitrary and least restrictive. I hope that I articulated that correctly. And believe it or not, of all the places where there's no mask mandate indoors in Knox County, one of the exceptions are nursing homes. So you'd think, okay, if this is going to really protect people, then surely the most vulnerable population to COVID, everybody in a nursing home, retirement home, home for the aged, is going to be required to wear a mask. And it's the opposite. Actually, nobody is required to wear a mask in a nursing home or retirement home. That to me beats all. And there were some other examples of arbitrariness.
I made when I challenged the mask mandate in federal court, I did make the argument that it didn't pass rational basis review, which it for those of you listening who don't know, kind of like Chris was talking about earlier, unless you're challenging some restriction to like religion or something that the left cares about, like abortion in certain trimesters, all the government has to do is pass what's called rational basis review. And that's basically that there's some government interest in doing what they're doing, and there's some rationality behind whatever tyranny they're imposing. And I made the argument that, well, there was a lot of irrationality in what our governor was doing. And one of the places I pulled that from was Judge William Stickman's opinion out of the Western District of Pennsylvania, which I'm sure you've read and enjoyed.
Yes.
And I pulled a lot of that out in the case I argued in the Southern District of West Virginia, and I got no traction with it, but it made a lot of sense to me. And that, for instance, is the essential versus non-essential. I mean, how irrational and arbitrary is it to have the government decide what businesses are essential and therefore able to remain open, and what businesses are non-essential and therefore must close, when at the same time they have no rational guide for how they're coming up with this. They're just arbitrarily coming up with it. And we have a word for that, and it's that it's irrational. I think it was a great claim. It's just a problem that the judicial reality is that just pretty much everything passes a rational basis review, unless it's because of skin color or something like that.
Have you checked in with Thomas Renz in Ohio and the progress of his case? Are you familiar with him?
No, is that the Stand Up Ohio or something like that, or is that a different one?
I believe that's correct. I think he's in Eastern Ohio, and he filed a federal lawsuit back last summer that received some attention. And last I checked in with him, he'd gotten the go-ahead to get discovery. So he made it past all his initial disclosures, and I guess he made it past a motion to dismiss, but I haven't heard anything since then.
Yeah, that must be it. Thanks, Bill. OhioStandsUp.org. When that was first going, I had a lot of people contacting me about that, and I had looked into it back then, but I've since gotten sidetracked. So no, I should probably touch base with that guy. But here's before I get to that, let me just point out why I'd left this up on the screen. This is sort of the illustration that people have no idea that this is the case. So a micron versus a human hair. So this is a human hair, the diameter of a human hair, and it's 4,000 times the size of a micron. And so a micron is just a teeny tiny little thing. And so a particle of COVID-19 is less than 1 micron. So it's more than 4,000 times smaller than the diameter of one single human hair. I mean, that's what people think that they're stopping when they're putting on their mask before they go into a store. Or, it literally is, when you look at it in scientific terms, it really is absolutely laughable, because for all the heartache and damage that the masks are doing, or the forced mandates of the mask, I mean, it literally does nothing. It does nothing. And Fauci admitted that at the very beginning. And that's, I think, what that guy Steve Deese wrote. What he wrote a book on Fauci. I heard him talk about it, and that's on my list of books to get.
I got several copies.
Really?
Yeah. I'm going through it right now. I think it's going to be a really good resource for people like us, because, that was something when I filed the case against Knox County, I tried to recruit people to, help me get, the scientific information I needed to put in my pleading. But, really it just came down to me doing it. And so I had to go out and do all the research. And I used actually some of Thomas Wren's information. I used, stuff that was provided by Daniel in some of his interviews. I used stuff provided by Steve Deese. But, you still have to go out and get it. And it's nice now that it's in one location that has a lot of footnotes, to serve as a resource while you're litigating these things. And, if I do end up filing a Section 1983 against Knox County, I plan on using that information in there as well, because there's a ton of information out there, but it takes time to corral it.
Yeah, that's a difficult thing. Is it's hard to find the time to spend the enormous amount of hours that it takes to put these challenges together. And the other thing is that it's crazy that really the only lawyers that are challenging these things is a lot of times, just little guys, like I'm a solo practitioner. I think you're a solo practitioner, aren't you?
That's right. Yeah.
And
I'm a divorce lawyer, man. That's what pays the bread and butter for me is divorce lawyer, family law.
Yeah,
I'm a family law lawyer.
And I think Chris has a little more help, but not a whole lot. And so it's just been little guys that, of course, that's who defends the Constitution really anyways, is it's just the little lawyers are doing it every day in court, or used to be in courtrooms all over the country. It's just like, a lot of times it's just a public defender or something that's literally defending somebody's constitutional rights, and the government's on the other side with what I refer to as a conviction machine that really can't be stopped. And that's really the irony of this whole thing. But you would think that there at least would be other groups, interest groups, think tanks, whatever, that would be challenging. It's sort of like you have in the gun rights world. Well, there's obviously no counterpart for just regular old everyday freedom. I mean, there's nobody. I can't believe nobody else challenges this stuff. And I guess the reason is because it doesn't, it's so unlikely to win that they know it's not going to be a good financial decision. And I suppose, and so they're not willing to do it. But I mean, somebody's got to do it.
Yeah. Well, I mean, a lot of my efforts have been pro bono. I've gotten paid some, but I've sunk my own time capital into this because, like you said, somebody's got to do it. And of course, the way I even got into this in the first place actually was in 2010. I describe myself as a Heath Ledger from The Patriot. You remember that movie, The Patriot?
Absolutely.
Heath Ledger was the son. He's like, there's this revolutionary war going on, and I'm sitting over here doing nothing. And, back around then, I recognized, because, Obama had become president, and I recognized that there were real legal battles, worldview battles going on, and I wanted to be a part of that. I wanted to do my part. I wanted to have a clear conscience, at the end of my days, that I had done everything I could to try to, protect the world that I grew up in for my children. And so, anyways, I attended an Alliance Defending Freedom seminar and got a little bit schooled on how to file civil liberties lawsuits, and I actually was local counsel for them once or twice. I was local counsel for Freedom X. I don't know if you heard of those guys. I was local counsel. Right now, I'm local counsel for Thomas More Society. So, I wanted to be involved in these kinds of battles, and I was willing to, give my time to do it. I filed Second Amendment lawsuit of, it wasn't really Second Amendment, but a guns rights lawsuit against the city of Knoxville several years ago. So, I've kind of been dabbling in it the whole time. But it would be nice to have some of the heavyweights involved. One of the things that I heard was that, some of these think tanks, their charter actually prevents them from expanding beyond, what they were set up to litigate. So, like maybe ADF is only established to litigate First Amendment stuff, and so this is really outside of their purview. I don't know if that's true, but it would be nice to, have some other, guys that are really experiencing this partake.
Yeah, I had a lot of, I mean, the as far as I've sued our governor 3 times, I think it is now, in the past year, and the support from just everyday people has been overwhelming, just from the citizens. I mean, it has been overwhelming, but it's just crickets. And also, I mean, a lot of the politicians, legislators have been willing to jump in and put their money where their mouth is, or go out on a limb for these things. But it's been crickets, really, other than that, other than lawyers sort of behind the scenes. And I've even had big Democrat lawyers, trial lawyers and stuff behind the scenes, like cheering me on anyways. And maybe they just kind of wanted to it was sort of a win-win for them, maybe. But yeah, I think that's why it's a good thing that sort of, some of us get together and team up on certain things, because I think that it's sort of like the rattlesnake deal, like join or die. I mean, if that's going to be the only way to beat the government, is to join power, with other states, with other grassroots groups, with other lawyers. Because I think, I said a long time ago, I think this mask thing is going to be the end of us. I mean, it just is. It's not because you're wearing a mask that's uncomfortable. That has nothing to do with it. That's besides the point. It's the fact that they've established that the government can do anything it wants to you, anything, whenever it wants, however it wants, and there's nobody going to stop them. If we can't stop them with the mask mandate, the way it was done under these circumstances, we can't stop them from doing anything. I mean, it really is. And that's always the case with constitutional rights. And that's always the hard part, is explaining to people and convincing them that even though you don't like this guy that had this encounter with the police or with the government, even though maybe you don't like this person, he's not somebody you want to rule in his favor, and you're generally supportive of the police, it's in your own best interest to enforce this guy's rights, because one day you might need to enforce your own rights, or your son or your grandson. And it always happens that somebody has like this encounter with the government, and it's their first time realizing that the government is not always there to help them. And they really had no idea throughout their entire life, and they learned the hard way, and it was too late. And so if you don't enforce the rights of some guy you disagree with, or some guy even you don't like, then you're also weakening and diluting your own constitutional rights. And that's bad. But it's hard to get people to understand that. And it's even worse here.
I realized that when I went to that first ADF seminar, I think it's the case of Board of Regents versus Keishian. Wasn't that a case in the late 80s where I think maybe homosexuals wanted to have their books in a library, a college library, I think, and they were being censored. And you never know. Am I right? Do you recognize that case? Is that the right one? Or
my brain doesn't hold. It's not in there anymore. If it was, okay. Maybe it was.
Well, anyways, I mean, what I realized was, 30 years later, that worldview, my worldview, that was censoring that information now is in the minority, and the other worldview is censoring my worldview. And I realized, just like you said, you need to protect civil liberties for everybody, because you eventually will likely be the beneficiary of ensuring that government stays within its constraints that are laid out by the Constitution. That's why rule of law is important.
Well, there's so many similarities between what's happening now and like 1933 Germany. I mean, there really are a lot of eerie similarities, and hell, there's similarities between what's happening now and George Orwell books.
Oh yeah,
and it's not just the COVID fascism, but there's all sorts of fascism going on. Ironically, really, it is fascism. Coming from the side that says they're fighting fascism, but that's what it is. And it's coming from a bunch of different directions right now. But hell, if we can't stop them from forcibly masking kids and restricting the breathing ability and learning ability of children, I mean, we can't stop the government from doing anything. And, if we can't convince people that this mask stuff is ridiculous. I mean, people are still free, like where Chris is in Florida. People are still wear a mask. They can wear a mask wherever they want to. No one's going to stop them from wearing a mask. But the fact that the government is going to force all of us, and especially our kids, to wear a mask, I mean, it's just so far out of line with anything we ever expected to see. So if we allow it to stand, we really have, the only rights we have left is what the government, decides to bestow upon us, and their generosity. And we'll never be able to force anything. And I think the importance of going to federal court is because we just know that the state courts are not going to do anything, even though the separation of powers argument is so good. Hell, every legislature in the country has met at this point, and I'm not aware of really one of them actually putting an end to this stuff. So, excuse me. Yeah. So, what do you think's next for you? I mean, you talked about wanting to file a Section 1983 case. Was that against the school? I mean, so you were, on behalf of kids, sort of the same thing that I was thinking of.
That's the next thing is I want to put together a Section 1983. I'm also looking into ADA cases. I have, several people who want me to pursue an ADA claim. The problem is, I emailed Daniel about this. Like I said, my bread and butter is family law. That's what I do to support myself. And I have a number of cases out there. I don't get donations from people like these think tanks and stuff. And so, I can only dedicate so much time to getting up to speed on complete new types of law. So, and sometimes it'll take 3 or 4 months in my spare time to really feel like I am in a position to proceed. So, I did really accelerate it on this, on the case against Governor Lee. I put that together in about 4 weeks, I think. But it took about 6 weeks to get the mask mandate suit up. And, every time that I take on a new kind of case, it just takes time to get that going, get the flywheel going and get all the theories under my belt to make sure that I'm, articulating something that doesn't leave any gaps, I can't get attacked on. So I have to learn the ADA law. I have to learn, the Section 1983 stuff. I know that. So that's not going to take that much of a spin up, but the ADA case is going to take some spin up because I don't know anything about ADA law. Have you filed any of those kinds of cases?
No. It's somebody asked a while back in a comment about some of the ADA issues, and I've looked into them. I think Chris knows a lot more about them I do. I think I asked him about it last time that we had talked. The one of the problems with the ADA is that it only applies to what the larger corporations. So like 40, I think it's 40 employees or more. And my question to him, I think, was, well, all right, if Taco Bell or Wendy's or whatever is really, forcing you to wear a mask despite your provable disability, well, they may obviously Wendy's has more than 40 employees, but maybe they don't at that particular store. I don't know the answer to that yet. I haven't researched that of
like
where
a franchise.
Yeah, I don't know if the franchise gets to use other franchises when adding the employees. I'm not sure about that, but the important thing is the ADA doesn't apply everywhere. So it, and I'm at the point where I think if there's evidence that children are being harmed, and I know people are being harmed because I see them touching their face constantly with the mask. So if there's something on their hands, it's in their body. I mean, like it's in their lungs now, no doubt. So, I mean, I can see that there's harm being caused, but there's other depression related stuff. I'm to the point of now these companies are becoming an arm of the government. And I've had about enough. I'm ready to start suing companies. I think we had talked about picking one and sending somebody in there and setting up a plaintiff situation, like maybe against Dick's Sporting Goods or who was it, Nike outlet store or something. I think, Nike outlet store is what we were talking about. But yeah, I think those suits need to be filed. But yeah, that's not my wheelhouse either. I've never litigated an ADA case. I get lots of questions and people who want to file those cases, but I don't know. I assume that there's people filing those around the country, and I probably should research how they, what they've been doing. But the trend is nothing works. Nothing works. But
I know there's a guy, Misha Seitlin, I think is his name. I attended a Federalist Society Zoom conference where he spoke, and he was involved in one of the New York cases. I wish I should have looked before I got on, but so he mentioned that he got involved in an ADA case, and we could probably use Pacer to figure out where he's filed and use his complaint as a template. Just, I'm sure there's plenty of non-lawyers watching this. And the big joke is when you're in a law school course, you can't plagiarize anything. But once you get out into the real world, that's the accepted practice, is to, plagiarize everybody else's work because no one wants to have to reinvent the wheel.
Right. Well, some of the best stuff I plagiarize is the written opinions of judges that I'm arguing to. So, what's better than that is copy and pasting exactly what they've written in an older opinion and presenting it to them again.
I was in divorce court one time, and that's what this lawyer read, and he was reading an opinion. He said, "And who is that learned judge who? Yeah, why, it's you, Your Honor." That was great.
Yeah, you ought to watch some of the family court stuff that's going on here in West Virginia. You probably haven't been following it, but this is one of my personal cases. I've got a client who had his home searched by a family court judge. This is a year after a divorce. The ex-wife, through her lawyer, files a petition for contempt, saying she didn't get all of the items of personal property that was in the divorce agreement. DVDs, family pictures, chainsaws, stuff like that. And so he shows up to the contempt hearing. This is a year and a half or almost a year and a half later, and he doesn't have a lawyer this time because he can't afford one or whatever. And so the judge, without making the ex-wife's lawyer prove that he was in contempt, or without giving him an opportunity to really respond or purge his contempt, she just says, "All right, what's your address? I'll be at your house in 10 minutes. And she takes the bailiff and orders the parties to his front yard, and they show up in his front yard. So he starts filming this at this point and recording it, audio as well. And he makes a motion on video for the judge to recuse herself. The 26-year family court judge to recuse herself, as she's now made herself a witness. She says, "No, I deny your motion is untimely." You know, he had no notice that this was happening, or would be happening, or even what she was looking for. So she's going to go in his house and bring the ex-wife and her lawyer in there and the bailiff, and they're going to go see if these items are in his house. And I don't even believe this was the marital home or anything. I mean, it's just his house. And so he moves to recuse her. She says no. And then he says, "Well, I want a search warrant. You're not getting in my house without a search warrant." And she says, "Oh, yes, I am." And then she threatens to throw him in jail. And he's threatened with incarceration like 7 times. And this guy is a federal law enforcement officer. This is his job. And so he knows what's going to happen to him if he tries to assert his rights any further. So he has no choice but to let this family court judge in his house with like 3 cops and with the ex-wife, her lawyer, and they go through his stuff, go through his safe, and basically search and seize inside. And they took items, even including some items that were never on any list.
Wow.
And that's what happens. And so he came to me, and I uploaded the video to YouTube, and it went viral. And next thing you know, it's on the news, and the state opens an investigation. The Judicial Disciplinary Commission, they opened an investigation, kind of sua sponte. And to make a long story short, the judge ends up getting a formal statement of charges from the disciplinary branch of the state. And they work out a plea deal. So the story it never ends. They work out a plea deal where the judge admits to all these judicial violations, Rule 2.2, 3. All these rules. She admits to it and admits that shouldn't have done it. And they agree on discipline. And the discipline was a censure and a maximum fine of $5,000. So the only thing she didn't get was a suspension. Mm. And that's the agreement. The judge, her counsel agrees to it. I mean, she has, the best lawyer, money could buy for a judicial disciplinary hearing. He agrees to it. Basically the prosecutors agree to it. And so there's the process in West Virginia requires it go to a judicial hearing board. And so the judicial hearing board, hears the testimony if it's disputed. Or if there's a plea deal, they adopt the plea deal or recommend it, or they can reject it. And then their recommendation goes to the Supreme Court. The Supreme Court makes a final decision. Well, what happened is it goes to the Judicial Hearing Board, and I spoke briefly there on behalf of my client. We thanked everybody involved, and we agreed to the agreed discipline in the case as the victim. And turns out there was a sitting family court judge on the Judicial Hearing Board. So there's like one circuit court judge, one family court judge, one magistrate court judge, and then like some lawyers and then some regular folks. That's how it's supposed to be comprised. So the family court judge, he causes a big stink during the hearing. He says, "Well, wait a minute. As a practicing lawyer, I was involved in doing these. I don't see any problem with doing these." And he said that before the hearing started or finished. And
you mean with the
searches,
being the executive branch,
right? So he
executing the judgment,
right? So the judge had referred to these as views, home views, and the initial defense was well, I thought it was legal because the regular judges have jury views. So I figure family court judges can do home views. And she admitted that there was no statutory or any sort of legal authorization for this. You're just making it up. It was just, she was speculating that this sort of implied power must exist. Then she admitted that it didn't and agreed to the censure. And there was another of her colleagues that was given a written reprimand for doing it only twice. And so she admitted to doing it over 20 years. But this family court judge basically disagrees and asks the parties to submit briefs on why this is illegal. And so they do that. And I actually did an amicus brief for it. So the prosecutors asked for this judge to make a long story short, they lowered the discipline. They lowered the punishment and the recommendation sent it to the Supreme Court. And this particular family court judge voted no for anything and took the position that it was legal. So the prosecutors, the disciplinary council, took objection to that to the Supreme Court, and also objected to him being involved in the decision because he was biased, had preconceived decision that he had made about whether or not, before he heard any of the evidence, all that sort of stuff. So anyways, just on Friday here of this week, a legal newspaper, the West Virginia Record, comes out with this sort of exclusive breaking story that this family court judge from the Judicial Hearing Board had written a letter to like every politician that has anything to do with the justice system or the family court system, asking basically for this prosecutor to be fired, this judicial disciplinary lawyer to be fired. And hey, doggy, I got a visitor here. But yeah, to like the legislators in the Senate, like the Speaker of the House, every Supreme Court justice, all these judicial and legislative officials have this letter from this member of the Judicial Hearing Board demanding that this prosecutor be fired of this pending case. It hasn't even been heard at the Supreme Court yet. And it's just, it's I haven't even done a video on this yet, but it's bizarre. Sort of reminds me of like Biden trying to get getting the prosecutor in Ukraine fired. I guess it worked out for him, but I don't see how that's going to work out. Like basically writing a letter to the judge and to the legislature asking the prosecutor be fired. I mean, I can't imagine that is going to end the way he thinks it's going to end. But anyways, we have all this drama going on in the family courts over here, and I filed a 1983 suit here 2 weeks ago or so to litigate the search and seizure. So
wow.
You take a look at the video. It's on my YouTube channel. It's bizarre.
I look
to say the least
to keeping up with that one. That is bizarre. It's my understanding. I think in what is it? That's the Dutch version of jurisprudence, that the judge is also the prosecutor, right? In that what was going down, she decided to just go get her own evidence and present it.
Yeah, well, I mean, that's why she admitted to all sorts of violations of the Code of Judicial Conduct, because, I mean, there's a bunch of them. So you can't, basically, she was admitting to improperly inserting herself into the case as a litigant because she didn't require or even request that the other lawyer prove contempt. She was going to prove contempt, for him. Right. Basically. And so she went there and she was going to, search the house herself. So not only is she a litigant, but she's also like, law enforcement, the executive branch here at this point. She hasn't found him in contempt. She hasn't issued a court order ordering the seizure of any personal property at the guy's house, but just it's going to be more efficient for her to just go there and see for herself. And then she can verbally order the seizure and already have law enforcement there and have the parties there, even though it's not recorded. And I mean, it's just so efficient. I mean, in fact, criminal cases, I mean, why do we go through all the stuff that's going on with the Chauvin trial right now? And it is probably mostly a show trial, but why even, there are more efficient ways of doing it. So, we could just do it from Chauvin's living room and go through his closet while we're there. And I'm sure there's all sorts of skeletons in his closet, and the jury can be right there inside his bedroom and it could be so much more efficient, and the rules don't say you can't do it. They don't say you can't do it.
Who needs rules of evidence, right? We just can blow right through that. Well, I've got to, speaking of family law, I still have to fax somebody a motion and a notice for next Monday. So I better finish up.
Yeah. Well, I appreciate it. Thanks for coming on. And I truly enjoyed, talking with you, and hopefully you'll come on again, and we can continue to scheme together on how to best defeat these governors. And I'm glad that Daniel Horowitz put us in touch, and look forward to talking to you many times in the future.
Yep. Look forward to it. My pleasure. Thank you very much for having me.
All right. So that was a great discussion. I really enjoyed that. And thank you to Chris Wiest for joining us from his vacation in Florida, from a free state right now. And so again, that was earlier Chris Wiest from Kentucky, and a very successful civil rights lawyer from Kentucky. And just speaking there was Andy Fox from Knoxville, Tennessee, and Daniel Horowitz from the Conservative Review podcast and The Blaze put me in touch with Andy. And I think that we'll have a good trifecta there to best challenge some of this stuff in our states of West Virginia, Kentucky, and Tennessee. And hopefully we can expand that to some other lawyers who feel the same way that we do and aren't afraid to take on the government on some of these issues. Because as I've explained, unless we beat this thing, again, this is the point that everyone's missing. If we allow them to mask forcibly our children, the most vulnerable among us, and at the same time, scientific evidence shows that many of those children are seeing physical and emotional harm as a result of that. If we can't stop that, then we've lost our liberty. The government can do whatever it wants to us, however it wants, for as long as it wants. So this is that hill to die on. If we don't beat this, it's not about the inconvenience of wearing a mask. That's not what it's about. It's about what can government do to us as citizens, and what can't it do? Are there any restrictions on what it can't do? That is what this is about. And if people don't see that, they're either purposefully ignoring that or trying to get around that because they want the government to do this, or they're just not that smart. So one component of this that's going to be important is the educational component. I would like to draft a lawsuit here that can be used, or that is used in multiple states, but people can read it, not just judges, but people can read it and look at the science, at the expert testimony that will be attached to it, and learn things sort of like we've displayed here, that masks don't do what you think they're doing, because aerosols, I mean, if COVID-19 is in this room, breathed aerosol out of somebody's mouth, even if they're wearing a mask, it goes right through the mask or around the mask like it's not even there. And hell, it could be floating there for 60 hours for days. So it doesn't matter if you've stayed 6 feet away from the person. It's almost like it's going to spread indoors. It's going to spread indoors no matter what kind of mask you wear, nor how many masks you wear, nor how many feet you stay away from people. It's going to spread indoors. The only thing that you can do is go outside, increase the ventilation, or buy some sort of technology that destroys the virus, which exists, none of which our government is doing. They're obsessed with the masks. And the point, the other good thing about concentrating on children and having that fight on that hill with our kids is because what's going to happen when I sue Jim Justice, who, by the way, is no longer a billionaire out today. I think it was out in Forbes because of all his lawsuits and debts. What happens when I hammer the governor with this new case, and it's in the news. The people are behind it. They're reading it. They're getting the educational aspect of it. They're tired of it. They've had enough, and they're finally standing up. They're burning their masks, and he just says, "All right, I'm gonna get rid of the mask mandate." Well, what's going to happen? We know from Texas that what happens then are these communist school administration folks, not all of them, of course, but there are some, many probably in the state, the teachers' unions, they are going to still have mask mandates in their public schools. That's what happened in Texas. That's what's going to happen. So this has to be done in such a way that is going to prevent that from happening. So if we beat the mask mandate, it's not just the governor can't do it, but it's that these schools can't do it. So that's what one of the numerous things that I'm working on right now. And I'll put links to some of this stuff that I've been talking about and showing up in the description as soon as I can, and on the website at thecivilrightslawyer.com. And hopefully I'll have a thorough presentation on Dr. Petty's material, and maybe I can have him on at some point. But for sure, he's willing to coordinate with us and presenting an affidavit in this litigation with all of his expert opinions, and combined with the German study and even the WHO's statements that they have on their website. There can be no dispute that children have been harmed by the forced usage of masks. So that is a worthy cause in more ways than one. I appreciate you for joining me through 2 hours and 1 minute of discussing this, and really appreciate Chris Wiest and Andy Fox from coming on. Those guys are patriots fighting in the trenches and in bigger states that I have here in West Virginia. So they've really gone out on a limb. They've taken on a huge fight, and I think we need to thank those guys, not just for BSing with me on here, but for the work that they do. So I'll see you next time. Hopefully, if the creeks don't rise, on Wednesday at 6:30, and have a number of topics we could talk about. Just filed an exciting case. I haven't released it yet, but maybe between now and then. So stay tuned. Make sure to subscribe to the YouTube channel. Make sure you hit the little bell symbol so that you're notified. Hopefully, a new video could drop at any time. Been busy filing cases. So that was Freedom is Scary, episode number 54, and it was a lot of fun. And have a nice evening.